Before we begin, a quick and important disclaimer. The following content regarding 401k assets, marital dissolution, and community property structures in the United States is provided strictly for educational and entertainment purposes. This video does not constitute professional legal, financial, or tax advice. Divorce and retirement laws are complex, vary significantly by state, and are subject to frequent legislative changes. The strategies and historical trends discussed here should not be taken as a substitute for consultation with a qualified attorney or a certified financial planner. Always conduct your own due diligence and seek expert counsel before making decisions that impact your financial future. In the next 24 hours, approximately 2,000 couples in the United States will file for divorce. For many of them, the single largest asset sitting on the table isn't the family home, the cars, or the savings account. It is a digital balance inside a 401k account that one spouse might have spent 30 years building. There is a common, often devastating misconception that because your name is the only one on that 401k statement, the money belongs solely to you. That assumption has led to what family law experts call the silver splitter crisis, where individuals entering their 60s realize, far too late, that half of their projected retirement security vanished in a single court order. We are talking about the difference between a comfortable retirement and having to re-enter the workforce at age 70. Most people assume the law is a blunt instrument that simply cuts everything down the middle, but the reality is a labyrinth of qualified domestic relations orders, or QDROs, and varying state-level definitions of what actually constitutes marital property. If you don't understand how your specific state views the growth of your investments from the day you said, "I do," to the day you filed the paperwork, you are effectively flying blind into a financial storm. This video is the definitive masterclass on 401k divorce and U.S. community structures. We are solving the fundamental problem of asset invisibility. By the end of this deep dive, you'll understand the precise mechanisms the U.S. court system uses to dismantle or distribute retirement accounts, the critical distinction between community property and equitable distribution states, and the specific tax traps that can turn a $500,000 settlement into $300,000 overnight. To understand where your money goes, we must first dissect the foundational legal structures of the United States. The U.S. is not a monolith when it comes to marriage. It is a patchwork of two primary legal philosophies: community property and equitable distribution. This is where the first major tactical errors occur. In a community property state such as California, Texas, or Arizona, the law generally views a marriage as a singular economic unit. Anything acquired during the marriage is owned equally by both parties, regardless of whose paycheck funded the account. If you started a 401k 3 years into your marriage and grew it to $1 million, the starting assumption of the court is a 50-50 split. However, the nuance lies in the commingling of premarital assets. Imagine you had $100,000 in your 401k before you got married. Over 10 years of marriage, you contributed another $200,000, and the total balance grew to $600,000 due to market gains. A community property court doesn't just look at the $200,000 you put in. It has to determine how much of that $300,000 in market growth is attributable to the separate premarital slice versus the community marital slice. Without meticulous record-keeping from a decade ago, many individuals find their separate property being consumed by the community pot because they cannot provide the tracing evidence required by the court. On the other side of the fence, we have equitable distribution states, which make up the majority of the U.S. Here, equitable does not mean equal. It means fair. While this sounds more flexible, it actually introduces a higher level of unpredictability. A judge in an equitable distribution state like New York or Florida will look at a variety of factors: the duration of the marriage, the health of each spouse, their respective earning capacities, and even their contributions as a homemaker. In these jurisdictions, a 401k might be split 60-40 or 70-30 depending on the equities of the case. This creates a high-stakes environment where the way you present your financial history can change your net worth by 6 figures. The 401k itself is a creature of federal law, specifically the Employee Retirement Income Security Act of 1974, or ERISA. This is a critical point that many overlook. Because 401ks are governed by federal law, they are protected from most creditors, but they are not protected from a spouse. To actually move money out of a 401k and into an ex-spouse's name without triggering immediate 10% early withdrawal penalties and massive income tax hits, you must use a specialized legal tool called a qualified domestic relations order. A QDRO is not just a paragraph in your divorce decree. It is a separate, highly technical document that must be drafted to the exact specifications of the 401k plan administrator. If the document says distribute 50% of the account, but doesn't specify the date of valuation, you could be arguing over tens of thousands of dollars in market fluctuations that occurred during the months the divorce was being processed. We have seen case studies where a spouse was awarded half the account during a market peak, but by the time the QDRO was processed months later during a market dip, the plan administrator didn't know whether to give a fixed dollar amount or a percentage of the remaining shares. These clerical ambiguities result in secondary legal battles that can cost more than the assets themselves. Furthermore, we have to talk about the shadow math of retirement assets. A 401k is a pre-tax asset. A house is a post-tax asset. One of the most common mistakes in U.S. divorce settlements is dollar-for-dollar trading. A husband might say, "You keep the $500,000 house, and I'll keep my $500,000 401k. On paper, it looks like an even split. In reality, the wife just received $500,000 in tax-free equity, while the husband received a $500,000 liability. When he goes to withdraw that money in retirement, he will owe federal and state income taxes. If he is in a 24% tax bracket, his $500,000 is actually worth $380,000. He just lost $120,000 in the negotiation because he treated pre-tax and post-tax dollars as equal. As we move through this deep dive, we will examine the specific tracing methods used by forensic accountants to protect premarital wealth. We will look at the Ziegler method and other accounting standards that attempt to separate the passive appreciation of your 401k from the active contributions made during the marriage. This distinction is the front line of the battle for your retirement. We will also explore the implications of 401k loans. What happens when you've borrowed $50,000 from your retirement to pay for a kitchen remodel, and now the marriage is ending? Does that debt follow the account, or is it a shared marital liability? The U.S. community structure is designed to ensure that neither party leaves a long-term marriage destitute, but the unintended consequence is a system so complex that the standard approach often leaves both parties poorer than they needed to be. Understanding the mechanics of the 401k split is not about being aggressive, it is about being accurate. It is about ensuring that when the dust settles, the numbers on your screen actually reflect the reality of your contribution and your future needs. This is about more than just a bank balance. It is about the structural integrity of your life after the gavel falls. Let's get into the step-by-step breakdown of the 401k anatomy and how the law views every dollar you've saved. To master the 401k split, we must first look at the anatomy of the account itself through the lens of a forensic accountant in 2026. Every 401k is essentially a time-stamped ledger. When a court looks at your retirement savings, it doesn't see one big pile of money. It sees a stratified layer cake. The bottom layer is your separate property, which consists of the contributions and growth that existed before the date of the marriage. The middle layer is the marital property, which includes every cent contributed and every bit of market appreciation that occurred from the wedding day until the date of legal separation or the filing of the divorce petition, depending on state law. The top layer is post-separation property. The danger lies in how these layers compress and blur over time. Imagine a professional named David. In 2018, David had $150,000 in his 401k. He married Sarah in 2019. Over the next 7 years, David continued to work at the same firm, contributing the maximum allowed by the IRS, while the market saw significant volatility and eventual growth leading into 2026. By the time they decided to part ways this year, the account balance sat at $500,000. David's first instinct might be to subtract his original $150,000 from the total and assume only the remaining $350,000 is up for grabs. This is a massive tactical error. In the eyes of the U.S. court system, David has to prove that his original $150,000 didn't just sit there but was specifically tracked. This brings us to the concept of the covariance or the time weighting of assets. If David's plan administrator shifted his $150,000 into different mutual funds during the marriage, or if he rolled over an old 401k into his current plan while married, he may have inadvertently commingled those funds. In many jurisdictions, if you cannot trace the separate property with near mathematical certainty, the court may default to viewing the entire account as marital property. This is why historical trends in family law show a shift toward hiring forensic specialists who use software to recreate the account's growth trajectory day by day. They look for the direct trace. Without a paper trail showing exactly how that initial $150,000 performed independently of the new marital contributions, David risks losing a significant portion of his premarital hard work. Let's look at a case study involving what we call the passive appreciation trap. Suppose the $150,000 David brought into the marriage grew to $250,000 simply because the S&P 500 went up, without David adding a single new dollar. In some states, that $100,000 in growth is considered separate property because it was passive. However, in other community property structures, if David spent even 5 minutes a month managing those trades or rebalancing the portfolio while married, a savvy attorney could argue that he used marital effort to increase the value, potentially transforming that passive growth into a marital asset. The 2026 legal landscape is increasingly scrutinizing the definition of active versus passive management in retirement accounts. Beyond the growth, we must address the 401k loan, which is a ticking time bomb in modern American divorces. As of 2026, a significant percentage of workers have outstanding loans against their 401ks for home down payments or debt consolidation. Imagine Sarah and David took a $50,000 loan from the 401k to renovate their kitchen. In a divorce, this isn't just a debt. It is a reduction in the marital estate. If David is the one who keeps the 401k, he is also the one responsible for paying back that loan with interest. If he leaves his job during the divorce process, that loan might become due immediately. If he can't pay it, the IRS treats the unpaid balance as a distribution, meaning David hits a massive tax bill and a potential 10% penalty if he is under age 59 and a half. The court might award Sarah half of the gross value of the 401k, leaving David to pay back the loan on her half as well. This is how a $500,000 account can feel like $200,000 very quickly. This leads us to the critical role of the plan administrator. Many people believe the judge has the final say, but in reality, the judge's order must be approved by the 401k's specific plan administrator. Every company, from Amazon to a local manufacturing plant, has a summary plan description that dictates how they handle QDROs. Some plans allow for a separate interest, where the ex-spouse gets their own account within the plan. Others only allow for a shared interest, where the ex-spouse only gets paid when the participant actually retires or takes a distribution. If you are 40 years old and get a shared interest QDRO, you might be waiting 25 years to see a single cent of that settlement. Historical trends show that many people fail to check these plan-specific rules before signing their divorce decree, leaving them tethered to their ex-spouse's employment decisions for decades. Now, consider the impact of the 2026 tax brackets. If you are negotiating a split, you must calculate the net present value of the 401k. A 401k is a bucket of future tax bills. If one spouse is in a lower tax bracket than the other, the 401k is actually more valuable to the lower-earning spouse. For example, if Sarah earns $45,000 a year and David earns $200,000, Sarah will lose much less of her 401k withdrawal to the IRS than David will. Sophisticated negotiators use this discrepancy as leverage. They might trade a larger portion of the 401k to the lower-earning spouse in exchange for more immediate cash or a larger share of the home equity. This is a strategic move that requires looking at the total financial picture through a multi-year lens. There is also the matter of the beneficiary designation. A common and tragic case study involves individuals who finalize their divorce but forget to update their 401k beneficiary forms. In many cases, federal ERISA law overrides state divorce laws. This means even if your divorce decree says your ex-spouse has no right to your 401k, if you die and they are still listed as the beneficiary on the plan's official paperwork, the plan administrator is often legally required to give them the money. We have seen instances where a second spouse is left with nothing because a decades-old form was never updated. This is a procedural pitfall that can negate years of careful legal maneuvering. As we peel back the layers of these community structures, we start to see that the 401k is not just a savings account. It is a complex legal contract. The intersection of state domestic relations law and federal retirement law creates a friction point where fortunes are often lost simply due to lack of technical knowledge. Whether you are in a community property state where the clock starts at the wedding, or an equitable distribution state where the judge weighs your moral and financial contributions, the math remains the same. You cannot protect what you cannot define. But what happens when the 401k isn't the only retirement asset? What if there is a pension involved, or a Roth 401k with different tax implications? And perhaps most importantly, how do you handle the valuation of these accounts when the market is shifting under your feet during the months of litigation? The timing of your valuation date could be the most expensive decision of your life. If you value the account on the day of filing versus the day of the final hearing, you could be looking at a variance of tens of thousands of dollars. In the next part, we are going to dive into the most misunderstood document in the entire process, the Qualified Domestic Relations Order itself. We will break down the specific language that must be in that document to ensure you aren't paying your ex-spouse's taxes, and how to prevent the plan administrator from rejecting your order and sending you back to square one in court. You will see why the QDRO is the only bridge that allows money to move across the marital divide without the IRS taking a massive cut. To understand the sheer power of the Qualified Domestic Relations Order, or QDRO, you have to stop thinking of it as a mere paperwork requirement and start viewing it as a sophisticated legal passport. In the United States, the Internal Revenue Code and the Employee Retirement Income Security Act of 1974, known as ERISA, create a high-security vault around 401k assets. Under normal circumstances, if you try to pull money out of your 401k to give to someone else, the IRS treats it as a standard distribution. This means you get hit with a 10% early withdrawal penalty if you are under age 59 and a half, plus the entire amount is added to your taxable income for the year, potentially pushing you into a 32 or 35% tax bracket. The QDRO is the only legal instrument that creates a sanctioned hole in that vault wall, allowing the transfer of assets while bypassing the penalty and assigning the tax liability to the person actually receiving the money. Let's look at a case study involving a character named Michael, who is navigating a divorce in 2026. Michael has $600,000 in a 401k. As part of the settlement, his spouse, Elena, is awarded $300,000. If Michael simply withdrew $300,000 from his account and cut Elena a check, Michael would owe approximately $72,000 in federal income taxes, assuming a 24% bracket, plus a $30,000 early withdrawal penalty. He would have essentially destroyed over $100,000 of his own net worth just to fulfill the settlement. By using a properly drafted QDRO, the plan administrator carves out Elena's $300,000 into a separate account. Michael pays zero taxes on that transfer. Elena then has the option to roll that money into her own IRA, continuing the tax-deferred growth, or she can take a cash distribution. If Elena takes the cash, she is responsible for the income taxes, but, and this is a critical historical trend in tax planning, the 10% early withdrawal penalty is usually waived for distributions made specifically under a QDRO. This is one of the very few ways a person under 59 and a half can access 401k funds without a penalty. The process of securing a QDRO is a multi-step administrative gauntlet. Step 1 is the drafting phase. You do not wait until the divorce is over to start this. In 2026, the most successful outcomes occur when the QDRO is drafted simultaneously with the settlement agreement. This document must contain specific identifiers: the name and last known mailing address of the participant and the alternate payee, the exact name of the plan, and the amount or percentage to be paid. But here is where the step-by-step details become dangerous. If you simply say 50% of the account, you are leaving the door open for disaster. Does that mean 50% of the balance on the day the divorce was filed? The day the judge signed the decree? Or the day the plan administrator finally processes the paperwork 6 months later? Imagine a scenario where the market experiences a sharp 15% correction in the middle of your divorce proceedings. If the QDRO specifies a fixed dollar amount of $300,000 from a $600,000 account, and the total account value drops to $500,000 during the administrative delay, the person holding the 401k is now left with only $200,000. They have effectively absorbed 100% of the market loss, while the ex-spouse remained protected. Conversely, if the account grew to $700,000, the ex-spouse would miss out on $50,000 of growth. To avoid this, a professional script for a QDRO often includes language regarding gains and losses. It might state that the alternate payee is awarded 50% of the account balance as of January 1, 2026, adjusted for market investment earnings or losses through the date of distribution. This ensures that both parties share the market risk and reward during the transition period. Step 2 is the pre-approval or qualification phase. You never submit a QDRO to a judge until the 401k plan administrator has reviewed it. Each major U.S. employer has a specialized QDRO department. If your document uses the term account balance, but the plan's internal software only recognizes total vested interest, the administrator will reject the order. This is a common point of failure that results in thousands of dollars in wasted legal fees. In 2026, many plan administrators offer a template or a set of required procedures. Following these to the letter is not just a suggestion, it is a mechanical necessity. If the plan administrator rejects the QDRO after the judge has signed it, you have to go back to court, amend the order, and pay for your attorney's time all over again. Step 3 is the joinder, which is common in states like California. This is a legal move where the 401k plan itself is joined as a party to the divorce. This prevents the plan from distributed funds to the employee spouse before the QDRO is finalized. Without a joinder or a temporary restraining order on the account, there is nothing stopping a vindictive spouse from liquidating the 401k or taking a massive loan against it the moment they realize the marriage is ending. Historical trends show that asset dissipation is a major risk in high-conflict divorces. By the time the QDRO is ready to be served, the money might already be gone, leaving the alternate payee with a piece of paper that is virtually impossible to enforce against an empty account. Another critical layer in this masterclass is the distinction between defined contribution plans like a 401k and defined benefit plans like a traditional pension. While 401ks are valued based on their current balance, pensions are valued based on future cash flows. Splitting a pension requires a completely different type of QDRO math. You have to determine the covered service period, which is the amount of time the person worked at the company while married, divided by the total number of years they worked there. This is known as the Majoska's formula in many jurisdictions. If Michael worked for a company for 20 years but was only married to Elena for 10 of those years, Elena is typically entitled to 50% of the 10-year marital portion, or 25% of the total pension check. However, the QDRO must also address survivor benefits. If Michael passes away first, Elena's payments might stop entirely unless the QDRO explicitly requires Michael to elect a joint and survivor annuity. We also have to account for the separate interest versus shared interest approach. In a separate interest QDRO, the alternate payee's portion is carved out and treated as their own independent retirement account. They can choose their own investments and decide when to start taking payments based on their own age. In a shared interest QDRO, the alternate payee only gets paid when the participant gets paid. This is a massive risk. If the participant decides to keep working until age 75, the ex-spouse is stuck waiting for their share of the money. In the 2026 economy, where people are working longer and retirement ages are shifting, the choice between separate and shared interest can have $1 million impact over a lifetime. But even with the perfect QDRO, there is one major factor that can still derail everything: the 401k plan's vesting schedule. If a company contributes matching funds to your 401k, those funds often don't belong to you until you have worked there for a certain number of years. If you get divorced while you are only 60% vested, the court can only split the 60% that is actually yours. If you are fired or quit before the remaining 40% vests, that money disappears for both you and your ex-spouse. The QDRO must account for what happens to unvested shares, or you might find yourself fighting over phantom money that doesn't exist. The complexity of the QDRO is exactly why it is the most overlooked phase of the divorce process. Most people think the decree is the finish line. In reality, for your 401k, the decree is just the starting gun. If you don't cross the finish line with the plan-approved, judge-signed, and administrator-processed QDRO, you haven't actually secured your retirement. As we move forward, we are going to look at the hidden costs that most attorneys don't mention, specifically the administrative fees that 401k plans charge just to process your QDRO. Some plans charge $500. Others charge $2,500 or more. Who pays that fee? If it's not in your settlement agreement, you might be in for a surprise. But more importantly, we are going to look at what happens when you have multiple accounts from different employers. Does one QDRO cover them all? And how do you handle the high-stakes world of the Roth 401k where the tax rules are flipped upside down? In the next part, we tackle the multiple account trap and the specific strategies for handling Roth 401ks versus traditional 401ks during a split. You will learn why treating them as the same asset type is the fastest way to lose 30% of your purchasing power in retirement. To grasp why the distinction between traditional and Roth 401ks is the single most common wealth leak in modern U.S. divorces, you have to look at the math of 2026. As of this year, tax laws have become even more stringent for high earners. For instance, if you earn over $150,000, any catch-up contributions you make to your 401k must now be categorized as Roth contributions. This means the average high-balance 401k is no longer a single-flavor asset, it is likely a hybrid. If your divorce attorney treats a $500,000 traditional 401k and a $500,000 Roth 401k as equal, they are handing over roughly $100,000 to $150,000 of your purchasing power to the other side for free. Imagine a couple, James and Linda. James has a traditional 401k worth $400,000. Linda has a Roth 401k worth $400,000. In a standard 50-50 split scenario, they might decide to simply keep their own accounts. On the surface, this looks fair. But fast forward to 2035 when they both retire. When James goes to withdraw his $400,000, he has to pay federal and likely state income taxes on every single penny. If he is in a 24% tax bracket, his actual usable cash is only $304,000. When Linda withdraws her $400,000, she pays zero in taxes because she already paid the IRS back in 2026. She walks away with the full $400,000. By failing to account for the tax character of these assets, James effectively lost $96,000 in the negotiation. This is what forensic accountants call the tax-adjusted net present value. In a professional masterclass negotiation, you must apply a haircut to the traditional 401k. Historical trends in family law suggest that instead of a 50-50th split of the balance, you should be looking at a 50-50th split of the after-tax value. If James and Linda wanted a truly equal outcome, Linda should actually receive less of the Roth account, or James should receive a larger share of a different liquid asset to compensate for his future tax liability. Now let's complicate this with the multiple account trap. Many Americans in 2026 don't just have one 401k. They have an active 401k with their current employer, two orphan 401ks from previous jobs, and perhaps a rollover IRA. Each of these requires a separate legal strategy. You cannot use one QDRO to split multiple 401ks if they are held at different companies. Each plan administrator has their own specific requirements, and more importantly, their own fee structure. Case studies in 2026 show that plan administrators are increasingly passing the cost of QDRO processing onto the participants. It is now common to see administrative fees ranging from $500 to $2,500 per QDRO. If you have 3 different 401ks from 3 different employers, you might be looking at $7,500 in just administrative fees before you even pay your lawyer. A savvy move in this situation is to consolidate. If the plan rules allow it, rolling those old 401ks into one current plan or into an IRA before the divorce is finalized can save thousands in paperwork. However, you must be careful. Rolling over a premarital 401k into a marital 401k can poison the well, making it nearly impossible to trace your separate property. You could accidentally turn $200,000 of yours into $100,000 of ours. Then there is the issue of the Roth 5-year rule. For a Roth 401k withdrawal to be tax-free, the account must have been open for at least 5 years. If a QDRO moves funds from a husband's Roth 401k into a brand new account for the wife, does her 5-year clock start over? In many cases, if she rolls it into her own existing Roth IRA, she can use the start date of her own IRA. But if she doesn't have one, she might find herself unable to touch that money tax-free for half a decade, even if she is already over age 59 and a half. This is a technicality that can trap a spouse in a liquidity crunch right when they need the cash the most. Step by step, the strategy for 2026 looks like this. First, you must categorize every dollar. You need a statement that breaks down the basis, the money you put in, versus the earnings, the growth. For a Roth 401k, the basis is always tax-free, but the earnings are only tax-free if you meet the age and 5-year requirements. Second, you must identify the matching funds. Many employers in the U.S. contribute a match, but those matching funds are almost always traditional, pre-tax, even if your own contributions are Roth. This means your Roth 401k might actually contain a hidden pocket of traditional money that will be taxed later. If your QDRO just says transfer 50% of the Roth account, you might be surprised to find that half of what you received is actually taxable. We also need to talk about the valuation date during market volatility. Imagine if your 401k is heavily invested in high-growth tech stocks. In March, your account is worth $800,000. By the time the judge signs the decree in June, the market has dipped, and the account is worth $650,000. If your settlement was written as a fixed dollar amount of $400,000, The spouse keeping the account just lost $150,000 of their own share because they were forced to pay the ex-spouse the full $400,000 from a smaller pot. In 2026, the standard of care is to use pro rata distributions. This means the ex-spouse gets a percentage of every individual investment in the 401k. They get 50% of the Apple stock, 50% of the bond fund, and 50% of the cash. This way, if the market moves, both parties feel the impact equally. But what if you don't want to split the account at all? There is a strategy called the offset. This is where one spouse keeps the entire retirement account and buys out the other spouse with other assets. For example, if there is $200,000 in a 401k and $200,000 in home equity, one person takes the 401k and the other takes the house. While this avoids the QDRO fees and the headache, it is mathematically dangerous. The person taking the house is getting now money that they can spend or use as a line of credit. The person taking the 401k is getting later money that is locked away and taxed. To make an offset work, you must apply a discount rate to the 401k to account for the lack of liquidity and the future tax burden. Plus one. As we go deeper, you'll see that the 401k is often just the tip of the iceberg. Many U.S. professionals also have restricted stock units, RSUs, stock options, or deferred compensation plans. These assets follow entirely different rules than the 401k. They are not governed by ERISA, and a QDRO won't work for them. If you try to use a 401k strategy on your company stock options, you are going to trigger a tax event that could cost you 40 to 50% of the asset's value in a single year. In the next part, we are moving beyond the 401k into the world of RSUs and executive compensation. You will learn why vesting is the most important word in your employment contract during a divorce, and how to stop your ex-spouse from claiming a share of a bonus you haven't even earned yet. This is where the real math of divorce separates the survivors from the victims. The math of divorce becomes exponentially more complex when you move from the stable, liquid environment of a 401k into the speculative world of executive compensation. In 2026, many professionals in tech, finance, and healthcare receive a significant portion of their total compensation in the form of restricted stock units, or RSUs, and stock options. These are often described as golden handcuffs, but in a divorce, they become a legal tug-of-war. The fundamental question the court asks is not who owns the shares today, but what period of time the shares were intended to compensate. This brings us to the concept of the time rule, or the Nelson formula, a cornerstone of United States family law that determines the marital portion of unvested assets. Imagine a software engineer named Marcus. In 2024, Marcus was granted 4,000 RSUs by his employer as an incentive to stay with the company for 4 years. These units vest at a rate of 1,000 units per year. Marcus marries his spouse, Maya, in early 2025. By the time they file for divorce in mid-2026, Marcus has already seen 2,000 units vest, while 2,000 remain unvested. Many people mistakenly believe that because the 2,000 units haven't vested yet, they aren't part of the marital estate. However, the court looks at the date of the grant versus the date of the marriage. Because Marcus was married during a portion of the time he was earning those unvested shares, Maya may be entitled to a percentage of them. The calculation usually involves a numerator representing the months of marriage while the grant was active, divided by a denominator representing the total months from the grant date to the vesting date. In Marcus's case, even though he received the grant before the marriage, a significant portion of the work required to earn those shares was performed while he was married to Maya. This creates a deferred liability. Marcus might be forced to share the proceeds of stock that won't even hit his account for another 2 years. This is a high-stakes scenario because if Marcus leaves his job or is terminated before the vesting date, the asset vanishes for both parties. Historical trends show that courts often handle this by creating a constructive trust, where Marcus is legally obligated to hold Maya's portion of the shares and deliver them to her only if and when they actually vest. But the 401k and RSUs are just 2 pillars of the retirement structure. To truly understand the 2026 landscape, we must look at the third pillar, Social Security. While you cannot divide Social Security benefits via QDRO or a divorce decree, because Social Security is a federal benefit governed by the Social Security Act, the rules regarding marriage duration are rigid and unforgiving. In the United States, if your marriage lasted at least 10 years, you may be eligible to receive benefits based on your ex-spouse earnings record, provided you are at least 62 years old and currently unmarried. Case studies frequently highlight the 10-year trap. Imagine a character named Robert who has been married for 9 years and 11 months. If Robert or his spouse rushes to finalize the divorce just 30 days too early, Robert loses the right to ever claim benefits based on his spouse's higher earnings record for the rest of his life. This doesn't take anything away from the higher earning spouse. It is a separate benefit paid by the government. Yet, the lack of awareness regarding this specific 10-year milestone costs American divorcees millions of dollars in cumulative retirement income every year. In 2026, with the cost of living rising, that extra $500 or $1,000 a month in Social Security benefits can be the difference between a dignified retirement and financial struggle. Furthermore, we have to address the recapture of marital funds used to pay for non-marital expenses. In many community property jurisdictions, if a spouse used 401k funds or marital income to pay down the principal on a house that was owned by one person before the marriage, the community may be entitled to a reimbursement. This is often calculated using the Moore-Marsden formula. Let's say Marcus owned a condo before marrying Maya. During their 2 years of marriage, they used Marcus's salary, which is a community asset, to pay $20,000 toward the mortgage principal. Maya doesn't just get $10,000 back. She may be entitled to a pro rata share of the appreciation of that condo that occurred during the marriage. This effectively allows the community to buy into the separate property of one spouse, creating a complex web of fractional ownership that requires a professional appraisal and a forensic accounting of every mortgage payment made. As we move deeper into the masterclass, we have to look at the valuation of the small business as a retirement vehicle. Many professionals in 2026 operate through S-Corp or LLCs and use simplified employee pensions, or SEP IRAs. These accounts allow for much higher contribution limits than a standard 401k, often up to 25% of net earnings. If you are a business owner, your retirement account is inextricably linked to the valuation of your company. If the company is valued at $1 million, but it has a SEP IRA worth $500,000, is the total marital estate $1.5 million or just $1 million? Historical trends in business valuation suggest that many owners double count or undercount these assets. The court will look at whether the contributions to the SEP IRA were made in lieu of a reasonable salary. If Marcus paid himself a tiny salary to keep his 401k contributions high and avoid taxes, the court might impute income to him, potentially increasing his alimony or child support obligations. The step-by-step reality of 2026 divorce is that every financial decision is a domino. If you settle the 401k using an offset against the house, you affect your future liquidity. If you split the RSUs using a constructive trust, you remain legally tethered to your ex-spouse for years. If you miss the Social Security 10-year mark, you leave federal money on the table. This is why the structure of the Statement of Assets and Liabilities is the most important document in your case. If an asset is missing from this list, whether it is a small cryptocurrency wallet, a forgotten 401k from a job in 2015, or a health savings account, it can lead to a motion to set aside the entire judgment years later. We also have to consider the survivor benefit problem in 401ks and pensions. Most people don't realize that a divorce decree automatically revokes a spouse's status as a beneficiary in many states. But as we discussed earlier, ERISA-governed 401ks often ignore state law. If you want to ensure that your children, rather than your ex-spouse, receive your 401k if you pass away during or after the divorce, you must obtain a specific waiver of beneficiary rights. In 2026, the law is increasingly clear. A general statement in a divorce decree saying each party keeps their own retirement is often insufficient to override a beneficiary designation form on file with the plan administrator. You need the spousal waiver signed, notarized, and filed. This leads us to the most sensitive and high-stakes portion of the 401k divorce: the early withdrawal strategy. There is a specific window of opportunity during a divorce where you can access 401k funds without the 10% penalty to pay for legal fees or to establish a new household. This is a surgical maneuver that, if done incorrectly, results in a massive tax bill. If done correctly, it provides a crucial lifeline during a period of extreme financial transition. In the next part, we are going to explore the Section 72(t)(2)(c) exception. You will learn exactly how to pull cash out of a 401k during a divorce to pay for your life without giving the IRS an extra 10%. We will also dive into the double-dipping controversy, where a spouse tries to claim a share of the 401k as an asset and then tries to claim the income from that same 401k as a source for alimony. This is the legal battleground where the most money is won or lost in 2026. To navigate the legal minefield of the double-dipping controversy, we have to look at how courts in 2026 view the friction between property division and support obligations. This is a technical nuance that can save or cost a participant tens of thousands of dollars in annual cash flow. Double-dipping occurs when an asset is counted twice. Once during the equitable distribution phase where it is split as a piece of property, and a second time when the court calculates alimony or spousal support by looking at the income that same asset generates. Imagine a character named Thomas. Thomas has a substantial 401k that was divided during his divorce from his spouse, Sarah. As part of the settlement, Sarah received 50% of the account. However, Sarah's legal team then argues that the dividends and required minimum distributions Thomas receives from his remaining 50% should be counted as income for the purposes of increasing his monthly alimony payments. In many U.S. jurisdictions, this is seen as an unfair bite at the same apple. Historical trends in states like New Jersey and Florida have led to specific case law that aims to prevent this, but the burden of proof often falls on the participant to show that the income is being generated by the very asset that was already divided. In 2026, the strategy involves a clear segregation of assets. You must be able to demonstrate that the funds being used for support are not coming from the post-divorce growth of a divided asset, but from active labor or other non-divided sources. This leads us into the tactical execution of the Section 72(t)(2)(c) exception. This is one of the most powerful, but least understood sections of the Internal Revenue Code for individuals going through a divorce in the United States. Under normal circumstances, if you are under the age of 59 and a half, and you take a distribution from your 401k, the IRS hits you with a 10% early withdrawal penalty. However, there is a specific exception for distributions made to an alternate payee under a qualified domestic relations order. Let's look at a case study involving a character named Jennifer. Jennifer is 42 years old and is the recipient of $200,000 from her ex-husband's 401k via a QDRO. Jennifer needs $50,000 immediately to put a down payment on a new home and pay for her legal team. If Jennifer rolls the entire $200,000 into a personal IRA and then withdraws $50,000, she will owe the 10% penalty, which is $5,000. But if Jennifer takes the $50,000 directly from the 401k plan at the time the QDRO is processed, before the money ever touches an IRA, the 10% penalty is waived under Section 72(t)(2)(c). She will still owe ordinary income tax on that $50,000, but she effectively avoids the early withdrawal penalty. In 2026, this is a vital liquidity strategy for spouses who are asset-rich but cash-poor during the transition. The step-by-step detail here is crucial. The check must come directly from the 401k plan as a cash distribution to the alternate payee. Once the money is rolled over into an IRA, that specific QDRO-based penalty protection vanishes forever. However, we must also address the impact of the Secure Act 2.0 and subsequent 2026 refinements on how these distributions are timed. The IRS is increasingly vigilant about what it calls the substance over form doctrine. If the IRS suspects that a QDRO was created solely as a sham to avoid the 10% penalty without a bona fide marital dissolution, they can challenge the tax treatment. Historical trends show that while this is rare, the paperwork must be pristine. The distribution must be clearly linked to the domestic relations order. Moving further into the mechanics of the split, we have to talk about the hidden liens and the 401k. In many U.S. states, a 401k can be attached for unpaid child support or past due alimony through a specific type of QDRO, often called a support QDRO. Unlike a standard property QDRO, a support QDRO can sometimes bypass the normal protections that ERISA provides. Imagine a scenario where a participant is $10,000 behind in child support. The court can issue a QDRO that directs the plan administrator to pay that $10,000 directly out of the 401k to the custodial parent. This is a significant shift in the 2026 legal landscape because it turns the 401k from a protected retirement bucket into an active enforcement tool. Now, consider the complexities of the 401k within the context of a prenuptial or postnuptial agreement. Many people in 2026 believe their prenuptial agreement is an absolute shield for their 401k. But there is a massive federal hurdle. ERISA. Federal law states that only a spouse can waive their right to a survivor benefit in a qualified retirement plan. Since a fiancé is not yet a spouse, A prenuptial agreement signed before the wedding is often insufficient by itself to waive 401k rights under federal law. Case studies have shown that even with a robust prenuptial agreement, the participant must have the new spouse sign a specific ERISA waiver after the wedding ceremony has taken place. If the participant forgets this step, and then passes away or gets divorced, the prenuptial agreement might be held as unenforceable regarding the 401k assets. This is a technical trap that has liquidated the retirement of many well-meaning professionals who thought they were protected. Step by step, if you are entering a marriage with a high-value 401k in 2026, your checklist must include: first, a prenuptial agreement defining the account as separate property. Second, a post-wedding ERISA waiver signed by the spouse. And third, an annual statement showing the balance on the day of the marriage to prevent commingling. Without these three pillars, the community property structures of the United States can easily absorb that premarital wealth. We also need to discuss the role of the 401k in high net worth scenarios where the participant has exceeded the standard contribution limits and has a supplemental executive retirement plan, or SERP. These are non-qualified plans. They do not follow the same QDRO rules as a 401k. You cannot simply tell a plan administrator to split a SERP. Because these are essentially contracts between the employer and the employee, they are often not assignable. This means the participant may have to pay the ex-spouse out of other, more liquid assets to compensate for the value of the SERP. In 2026, the valuation of these non-qualified plans is a major point of contention. Because they are often subject to the company's ability to pay in the future, a forensic accountant must apply a risk-adjusted discount rate to determine what that future promise is worth in today's dollars. This leads to the concept of the Internal Revenue Code Section 409A. If you try to split a deferred compensation plan or a SERP incorrectly, you can trigger an immediate tax event on the entire balance, plus a 20% penalty. This is why you cannot use a 401k template for an executive's deferred comp. The structural differences between a qualified 401k and a non-qualified executive plan are the difference between a controlled asset transfer and a financial catastrophe. As we look at the broader U.S. community structures, we must acknowledge that the 401k is often the only liquid part of the retirement puzzle. Pensions are slow, Social Security is fixed, but the 401k is a live, fluctuating market asset. This makes it the primary tool for horse trading in a divorce negotiation. You might give up more of the 401k to secure the family home, or you might take more of the 401k to offset a spouse's business interest. But every one of these trades must be viewed through the lens of the 2026 tax code. In the next part, we are going to dive into the nightmare of the orphan 401k. What happens when your 401k is with a company that has gone bankrupt, or a plan that has merged 5 times since you left? We will look at how to track down these lost assets, and why the Department of Labor's 2026 database is your best friend in a divorce. We will also explore the implications of the 401k in the context of late-life divorce, the so-called gray divorce, and how the rules change when you are already in the distribution phase. The battle for your retirement security is won in the fine print of the administrative records. If you don't know who your plan administrator is today, you are already behind in the negotiation. We are going to show you how to find them and what specific questions you need to ask to protect your share. To locate your plan administrator, you must first recognize that the 401k landscape in 2026 is often a graveyard of corporate mergers and acquisitions. It is a common historical trend for a professional to work for a company like a mid-sized tech firm in Seattle, only for that firm to be acquired by a global conglomerate 3 years later. If you left that company in 2018, your 401k didn't just stay in a vault with the old company name on it. It migrated. If you are going through a divorce today, the first step in your due diligence is using the Department of Labor's FAST-2 database. Every qualified retirement plan in the United States is required to file a Form 5500 annually. This form is public record and contains the name and contact information of the current plan administrator. If your old employer no longer exists, searching for the company's employer identification number, or EIN, on the 2026 DOL portal will reveal exactly which financial institution is currently holding those assets. Imagine a character named Susan. Susan worked for a regional healthcare provider from 2012 to 2019. She married Mark in 2015. During her divorce proceedings in 2026, she realizes she hasn't received a statement from her old 401k in 5 years. Mark's attorneys are demanding a current valuation to determine the marital portion of that account. Susan discovers that her old employer was absorbed by a national hospital chain. which then outsourced its retirement services to a third-party record keeper. By using the Form 5500 search, Susan finds the new plan administrator and discovers the account has grown from $80,000 to $140,000 due to passive market appreciation. Because she was married for 4 of the 7 years she contributed, a significant portion of that growth is now on the negotiation table. Once you find the administrator, the specific questions you ask will dictate the success of your QDRO. You must ask for the summary plan description and the specific QDRO procedures for that plan. Do not assume every plan follows the same rules. For example, some plans calculate the alternate payee share based on a specific dollar amount, while others strictly use percentages. You must ask if the plan allows for a separate interest, which creates a brand new account for the ex-spouse, or a shared interest, which ties the ex-spouse to the participant's retirement timeline. In 2026, failing to ask if the plan charges a QDRO processing fee can lead to a surprise $1,200 deduction from the account balance at the final moment of transfer. You must also ask about the valuation date. Does the plan value accounts daily, monthly, or quarterly? If the plan only values accounts on the last day of the quarter, and you finalize your divorce on the first day of the quarter, you could be stuck waiting 3 months for the transfer to occur, during which time a market crash could wipe out your settlement. This brings us to the phenomenon of gray divorce, a major trend in 2026 involving couples over the age of 50. In a gray divorce, the 401k is often already in the distribution phase or very close to it. The rules of engagement change significantly here because of required minimum distributions, or RMDs. Under the current 2026 tax code, once you hit the applicable age, the IRS forces you to take money out of your 401k and pay taxes on it. If a QDRO is being processed for a 72-year-old participant, you must account for the current year's RMD. If the participant has already taken the RMD for the year, does the ex-spouse get a credit for that in the property split? Or is the ex-spouse now responsible for taking their own RMD from their new separate account? Case studies show that if the RMD is not addressed in the divorce decree, the participant might end up paying taxes on money that was eventually transferred to the ex-spouse, creating an accounting nightmare. Furthermore, we must explore the 2026 implications of the 401k as a source for alimony buyouts in late-life divorces. Imagine a character named Robert, age 64, who wants to retire but is facing a $3,000 a month alimony obligation to his spouse Alice. Robert has a $1.5 million 401k. Instead of paying Alice monthly for the next 10 years, Robert's legal team proposes an alimony buyout using the 401k. They calculate the present value of the $30,000 a year Alice would receive and transfer that lump sum to her via a QDRO. This is a high-stakes trade. Alice gets the security of a lump sum that she can invest, and Robert gets to retire without the weight of a monthly check hanging over him. However, they must adjust for the tax-deferred nature of the 401k. Since Alice will owe taxes on the 401k withdrawals, the lump sum must be grossed up to ensure she receives the equivalent of the after-tax alimony she was expecting. The 2026 landscape also introduces the complexity of ESG and brokerage link accounts within 401ks. Many modern 401ks allow participants to open a window to trade individual stocks or specialized environmental, social, and governance funds. If you are splitting an account that has a brokerage link, the QDRO becomes much harder to execute. Most plan administrators cannot simply split a portfolio of 30 individual stocks 50-50. They may require the participant to liquidate the stocks into cash before the transfer can happen. This liquidation can cause the participant to miss out on market gains during the settlement period. Historical trends show that couples who do not specify how to handle these brokerage windows end up in extended litigation over which stocks should have been sold and at what price. Another critical step-by-step detail is the lost participant problem. In 2026, the U.S. government has ramped up efforts to reconnect people with forgotten 401ks, but during a divorce, an ex-spouse might try to hide an account by claiming they forgot the login or that the plan was terminated. You must look for plan terminations on the DOL database. If a plan was terminated, the assets were likely rolled into an individual retirement account or transferred to a state's unclaimed property fund. A forensic search of the last 5 years of tax returns is the most effective way to find these. Look for Form 1099-R, which is issued whenever there is a distribution or a rollover. Even if your spouse claims they don't have a 401k, a 1099-R from 3 years ago might prove they rolled $200,000 into a hidden IRA. In the 2026 economy, we also see the rise of the side hustle 401k, or the solo 401k. If your spouse is a consultant or a gig worker, they may have established a retirement plan for their one-person business. These plans are often more flexible than corporate 401ks, allowing for much higher contribution limits. Because the spouse is both the employer and the employee, they have total control over the plan documents. This creates a high risk of document tampering. If you are divorcing a business owner with a solo 401k, you must demand the adoption agreement and any amendments made to the plan in the last 24 months. You are looking for changes to the vesting schedule, or the definition of compensation that might have been designed to minimize your share of the assets. The complexity of these structures is exactly why Part 7 emphasizes the administrative audit. You cannot rely on a single balance sheet provided by your spouse. You must cross-reference the Form 5500, the Social Security Administration's potential private pension benefit notice, and the employer's payroll records. This isn't just about finding the money. It is about finding the date of every contribution to prove what happened during the marriage versus what happened before. As we conclude this section on administrative deep dives, we are standing at the edge of the most controversial part of the 401k divorce, the market manipulation trap. In the next part, we are going to look at how a spouse might intentionally change their 401k investment strategy to a low-growth or high-risk profile during the divorce to diminish the value of the account before it is split. We will learn how to use a status quo order to freeze the investment allocations, and why the choice of your valuation date is the final battle for your financial future. If you think the QDRO is the end, you haven't seen what happens when the market shifts 20% the day before the transfer. The market manipulation trap is one of the most sophisticated and potentially damaging maneuvers in the 2026 divorce landscape. To understand this, you have to realize that until the qualified domestic relations order is actually implemented by the plan administrator, the participant usually maintains full discretionary control over the investment allocations within the 401k. This creates a dangerous window of opportunity. Imagine a character named Daniel. Daniel has a 401k worth $800,000. Largely invested in aggressive growth equities. He knows that his spouse, Karen, is likely to be awarded 50% of the marital portion. During the 6 to 9 months it takes to litigate the divorce and draft the QDRO, Daniel decides to shift the entire $800,000 into a stable value fund or a low-interest money market account. While this might seem like a move toward safety, it is often a strategic attempt to stagnate the growth of the ex-spouse's future share. If the broader market gains 15% during those 9 months, the account should have grown to $920,000. By moving to cash, Daniel has essentially deprived the marital estate of $120,000 in growth. Because he didn't technically lose money, it is much harder for Karen to prove asset dissipation. Historical trends in 2026 show that courts are becoming increasingly sensitive to this type of fiduciary breach between spouses. The countermaneuver is the status quo order. This is a preliminary injunction filed at the very beginning of the divorce that legally forbids either spouse from making significant changes to investment allocations, taking loans, or changing beneficiaries without written consent or a court order. If you fail to secure a status quo order on day one, you are essentially giving the participant a free hand to gamble with or refrigerate your future retirement. Step by step, protecting yourself from the market manipulation trap involves 3 phases. First, you must obtain the most recent 401k statement immediately upon filing. This serves as your baseline. Second, you must demand quarterly, or in 2020 SIX's fast-paced environment, even monthly transaction reports. You are looking for shifts in the asset allocation. If you see a sudden move from a diversified portfolio to 100% cash, or conversely, a move into highly speculative options or triple leveraged ETFs, your legal team must file a motion to restore the previous allocation. Third, you must address the valuation date with extreme precision. In the United States, there are generally 4 types of valuation dates used in 401k splits. The first is the date of marriage, used as the starting point for separate property credit. The second is the date of separation, which in many states marks the end of the community interest. The third is the date of the divorce decree, and the fourth is the date of distribution. The gap between the date of separation and the date of distribution is the danger zone. Case studies from 2026 highlight that if your decree says you get $400,000 as of the date of separation, but the market drops 30% before the money is actually moved, the person holding the account may not have enough funds left to pay you that fixed amount. Conversely, if the market booms, you might be stuck with a flat $400,000 while the participant keeps 100% of the growth on your half of the money. The strategy used by high-retention legal teams in 2026 is to award a percentage of the account as of a specific date, plus or minus investment gains or losses. This ensures that the alternate payee is treated as a co-investor rather than a creditor. If the account goes up, both benefit. If it goes down, both share the loss. This is the only way to truly neutralize the incentive for market manipulation. However, we must also look at the high-stakes world of the 401k loan during this period. Imagine if Daniel, knowing he is about to lose half his 401k, takes out a $50,000 loan to pay for his personal legal fees or a new luxury vehicle. Under the 2026 tax rules, this loan is a lien against the total account balance. When the plan administrator goes to process the QDRO for Karen, they see a $750,000 cash balance and a $50,000 loan. If the QDRO is not specific, the administrator might calculate Karen's 50% share based only on the $750,000 in cash, effectively making her pay for half of Daniel's loan. To prevent this, the QDRO must specify whether the loan is included or excluded from the total balance for calculation purposes. In a professional masterclass negotiation, Karen's attorney would argue that the $50,000 loan is David's sole responsibility and should be added back into the total value before her 50% is calculated. This would mean Karen gets 50% of $800,000, which is $400,000, leaving David with $350,000 in cash and a $50,000 debt. If the lawyer misses this detail, Karen loses $25,000 instantly. Beyond loans and allocations, we must address the 2026 reality of participant-directed brokerage accounts, often called PCRA windows. Many 401ks now allow employees to transfer their balance into a window where they can buy individual stocks, cryptocurrencies, or even gold-backed ETFs. If a spouse moves the 401k into a PCRA and then claims the assets are too volatile to value, the divorce can be stalled for years. Historical trends show that the most effective way to handle a PCRA in a divorce is to order an immediate liquidation of the brokerage window back into the plan's core mutual funds. This creates a stable, liquid environment for the QDRO to operate. We also have to consider the impact of the 2026 inflation-adjusted IRS limits. For the current year, the maximum contribution for a 401k is $23,500, or $31,000 for those over age 50. If the divorce takes 2 years to finalize, the participant may have added $62,000 of post-separation property to the account. Forensic accountants must use a subtractive method to peel away these post-separation layers. This is not as simple as looking at the contributions. You must also subtract the specific market growth attributable to those post-separation dollars. If the $62,000 was invested in a fund that doubled, you have to subtract $124,000 from the final balance before you split the remainder. This level of detail is why the standard QDRO, provided by a plan administrator, is often a trap. Those templates are designed to make the plan administrator's life easy, not to protect your financial interests. They often lack the specific clauses needed to handle loans, market fluctuations, or post-separation credits. In 2026, a custom-drafted QDRO is a requirement for any account over $100,000. As we move toward the final stages of this masterclass, we have to look at the post-divorce execution. What happens after the judge signs the paper? Many people assume their attorney handles the rest, but historical trends show a massive drop-off in execution at this phase. If the signed QDRO sits in a drawer and is never served on the plan administrator, the transfer never happens. We have seen cases where participants retired and began spending the entire account because the ex-spouse never finalized the paperwork. In the next part, we are going to dive into the execution failure and how to survive the 401k split without getting stuck in administrative limbo. We will look at the 2026 rules for rolling over QDRO funds into an IRA, the specific codes you need on your tax return to avoid red flags, and what to do if your ex-spouse tries to block the transfer at the very last second. We will also explore the often ignored world of the 403b and 457 plans, which look like 401ks but have very different rules for teachers and government employees. The finish line is in sight, but the final hurdles are where the most settlements fail. To master the final hurdles of a retirement split, you have to look beyond the corporate world and into the specialized public sector accounts that millions of Americans rely on: the 403b and the 457 plan. In 2026, These are not just 401ks with different numbers. They are distinct legal animals with their own survival rules. If you are a teacher, a nurse, or a municipal employee, or if you are married to one, treating these like a standard 401k during a divorce is a high-stakes error. The 403b, commonly found in schools and nonprofits, is often referred to as a tax-sheltered annuity. While it mirrors the 401k in many ways, the way it is structured can vary between a custodial account holding mutual funds and an annuity contract. In a divorce, this matters because some older 403b annuity contracts have rigid surrender charges or specific withdrawal restrictions that a standard QDRO cannot easily override. If your settlement assumes you can just liquidize 50% of a 403b next Tuesday, you might be shocked to find a 7% surrender penalty waiting for you, effectively shaving thousands off your net worth before you even pay the IRS. Even more critical is the 457 plan, often called a deferred compensation plan for government employees. In 2026, the 457 remains the holy grail of retirement splits for one reason. It is generally exempt from the 10% early withdrawal penalty, while a 401k or 403b usually requires you to wait until age 59 and a half, or use the specific QDRO exception we discussed earlier. A governmental 457 plan allows participants or alternate payees to access the funds immediately upon separation from service, regardless of age, without that 10% hit. Plus 2. Imagine a character named Sarah, a 45-year-old firefighter divorcing her spouse, Mark. Sarah has a 457 plan. In their settlement, Mark is awarded $100,000 from that account. Because it is a 457, Mark can take that $100,000 as a cash distribution immediately after the divorce is finalized. He will owe income tax, but he bypasses the 10% penalty entirely. This makes 457 assets significantly more valuable in a divorce than 401k assets because of their superior liquidity. If Mark's lawyer doesn't recognize this, they might trade away $100,000 in a 457 for $100,000 in a 401k, not realizing they just traded flexible money for locked-away money. However, there is a catch. In 2026, we see two types of 457 plans: governmental and non-governmental. If you work for a private nonprofit, your 457 is likely non-governmental. These plans are not protected by ERISA. They are considered unfunded, meaning the money technically belongs to the employer's general creditors if the organization goes bankrupt. You cannot use a standard QDRO to split a non-governmental 457. Instead, you must use a different legal instrument, and the tax consequences are far more aggressive. Often, the entire balance must be distributed and taxed the moment the employee leaves the company, making it a tax bomb that can blow up your settlement if not handled with a forensic eye. Step by step, the 2026 strategy for these public sector plans requires an immediate plan classification. You must look at the top of the statement. Is it a 403b-7 custodial account or a 403b-1 annuity? Is the 457 governmental or non-governmental? This classification dictates whether you are filing a QDRO or a specialized domestic relations order. Historical trends show that many public sector plan administrators are smaller and less automated than giants like Fidelity or Vanguard. This means the turnaround time for your order can be twice as long. If you are trying to close on a house using funds from a school district 403b, you need to build in a 90-day buffer, or you risk losing your earnest money. Beyond the plan type, we must address the vesting and contribution changes for 2026. Under the Secure 2.0 Act and subsequent IRS updates, the contribution limits for 403b and 457 plans have increased to $24,500, with catch-up limits for those over age 50 hitting $8,000. If you are in that unique age bracket of 60 to 63, the 2026 catch-up limit is a massive $11,250. If a divorce is dragging on, the participant could be shielding an extra $35,750 per year in their 457 plan. If your valuation date is set to the date of filing, you might miss out on a massive amount of marital growth that occurred during the litigation. Plus one. Now let's look at a case study involving a character named David, a city administrator. David has both a 401k and a 457. In 2026, many high-level government employees are allowed to max out both plans simultaneously. David has been contributing the maximum to both for 5 years. His total marital retirement contributions are nearly $50,000 a year. During the divorce, David tries to argue that the 457 is deferred compensation, and therefore not a retirement asset subject to the same split as the 401k. This is a common legal feint. In reality, in almost every U.S. jurisdiction, if the money was earned during the marriage, the label on the account doesn't matter. It is a marital asset. By unearthing both accounts, his spouse is able to secure a settlement that accounts for the full $250,000 contributed during the marriage, rather than just the 401k. This leads to the execution failure phase. Even with the right plan identified and the right math applied, the settlement often fails at the 5-yard line. In 2026, the most common reason for a failed transfer is the missing rollover. When you receive money via QDRO, you generally have two choices: take the cash or roll it into an IRA. If you take the cash, the plan administrator is legally required to withhold 20% for federal taxes. If you needed $100,000 for a house but didn't account for the 20% withholding, you'll only receive a check for $80,000. To avoid this, you should roll the entire amount into a rollover IRA first, and then strategically withdraw exactly what you need. +1. But here is the 2026 red flag. If you roll 457 money into a standard IRA, you have just poisoned the asset. Once the 457 money hits the IRA, it becomes subject to the standard IRA rules, which include the 10% early withdrawal penalty. You effectively took a penalty-free asset and turned it into a penalty-trapped asset. Historical trends show that thousands of divorcees make this mistake every year, costing them billions in unnecessary penalties. As we approach the final chapter of this masterclass, we have to talk about the post-settlement audit. Just because the money moved doesn't mean you are done. You must check the 1099, are forms issued by the plan administrator in the year following the split. If they coded the transfer incorrectly as a distribution, instead of a QDRO transfer, the IRS will come looking for you. You need to ensure the distributions code in Box 7 is either a 2 or a G depending on the scenario. In the final part of this series, we are going to look at the ultimate checklist for the day your divorce is finalized. We will cover the specific steps to change your 401k beneficiaries, how to handle the health insurance COBRA bridge that often accompanies these splits, and the psychological transition from our retirement to my future. We will wrap up with the 3 questions you must ask your attorney before you sign the final decree to ensure you haven't left your future in a corporate vault. The final part is about closure, both legal and financial. The transition from a joint retirement vision to a singular financial future is the most critical phase of the entire 401k divorce process. In 2026, the finality of your divorce decree is a legal illusion if it is not followed by immediate, precision-targeted administrative actions. As we conclude this masterclass, we must address the ultimate checklist for the day the gavel falls. This is the moment where historical trends show a massive divergence between those who maintain their standard of living and those who suffer a permanent wealth reset. The first item on this checklist is the immediate revocation and replacement of beneficiary designations. In the United States, as we have established, federal ERISA law is the supreme authority over your 401k. Even if your final divorce decree states in bold text that your ex-spouse has waived all rights to your retirement, that decree is often insufficient to override the beneficiary form held in the plan administrator's digital file. Imagine a character named Christopher. Christopher finalized his divorce in early 2026. His decree clearly stated that he retained 100% of his 401k. However, Christopher was exhausted by the litigation and neglected to log into his benefits portal to remove his ex-wife, Maria, as the primary beneficiary. 3 months later, Christopher is involved in a serious accident. Under ERISA, the plan administrator is legally obligated to pay the entire $500,000 balance to Maria, regardless of what the state divorce court ordered. This is a recurring case study in American probate law. To prevent this, the moment your divorce is final, you must submit new beneficiary forms for every single account, including 401ks, 403bs, and IRAs. Furthermore, in 2026, many plans now require a notarized spousal waiver if you are remarried and wish to name someone other than your new spouse as a beneficiary. The administrative trail must be unbroken. The second item on the checklist is the COBRA bridge and the health savings account, or HSA. In the United States, many 401k participants also have an HSA tied to their high-deductible health plan. While the 401k gets all the attention, the HSA is a powerful triple tax-advantaged retirement tool. If you are the non-employee spouse, you are likely losing your health insurance coverage on the day of the divorce. You have a 60-day window to elect COBRA coverage, which allows you to stay on the employer's plan for up to 36 months in the case of divorce. However, the cost of COBRA is often 102% of the full premium. Step by step, you must evaluate whether it is more cost-effective to use a portion of your 401k QDRO distribution to fund your COBRA premiums or to transition to a plan on the 2026 healthcare exchange. If you are splitting an HSA, it does not require a QDRO. Under Internal Revenue Code Section 223, an HSA can be transferred between spouses incident to a divorce tax-free. If you miss this in your settlement, you are leaving behind an asset that is effectively a 401k for medical expenses. The third item is the 1099-R reconciliation. In the tax year following your 401k split, you will receive a Form 1099-R. This is where many individuals find themselves in a dispute with the IRS. If the plan administrator reports the QDRO transfer as a taxable distribution to the participant instead of a non-taxable transfer to the alternate payee, the participant will receive a massive, unexpected tax bill. You must verify that the 1099-R shows the correct distribution code. In 2026, the IRS has increased its automated matching of 1099-R forms to divorce decrees. If there is a discrepancy, the burden of proof is on you to provide the court-certified QDRO to the IRS to prove the transfer was incident to a divorce. This leads us to the 3 critical questions you must ask your attorney before you sign that final decree in 2026. Question 1. Does this decree specifically address the gains and losses on my share of the retirement account from the date of valuation until the date of actual transfer? As we have seen in previous parts of this masterclass, failing to include this language can result in a loss of tens of thousands of dollars if the market moves during the administrative delay. Question 2. Has the plan administrator provided a formal letter of pre-approval for the QDRO language used in this settlement? You do not want to sign a decree and then find out 3 months later that the plan administrator rejects the wording, forcing you back into a costly legal battle. Question 3. Is there a specific deadline in the decree for the participant to cooperate with the QDRO process? And what are the sanctions if they fail to do so? Historical trends suggest that without a clear deadline and a penalty for non-compliance, a disgruntled ex-spouse can stall the transfer of funds for years. We must also consider the psychological and structural transition from our retirement to my future. For decades, you may have been investing based on a 2-person household with 2 Social Security streams and a joint risk tolerance. In 2026, your individual risk tolerance may be significantly different. If you are the spouse receiving a QDRO distribution, you are suddenly responsible for managing a large sum of money. Case studies show that many people, out of fear or lack of experience, leave these funds in cash or low-yield money markets, allowing inflation to erode their purchasing power. Step by step, you must reallocate these assets to fit your new timeline. If you are 50 years old, your investment horizon is still 20 to 30 years. You cannot afford to be too conservative, but you also cannot afford the same level of risk you might have taken as part of a dual-income household. Furthermore, we need to talk about the recontribution strategy. If you are the participant who just lost 50% of your 401k, the 2026 tax code offers a path to recovery. Because the IRS increased the contribution limits for 401ks, you have the opportunity to aggressively rebuild your balance. If you are over age 50, taking advantage of the $31,000 annual limit, plus any employer match, can help you recover the lost ground over the next decade. This is not a quick fix, but the historical trajectory of the U.S. markets suggests that a disciplined recontribution strategy is the most effective way to mitigate the impact of a midlife or late-life divorce. As we conclude this masterclass, remember that the 401k is the cornerstone of the American middle class and upper middle class dream. In a divorce, it is the asset most prone to administrative failure, tax traps, and valuation errors. By understanding the intersection of ERISA, the Internal Revenue Code, and your state's community property or equitable distribution laws, you move from being a passive participant in your divorce to being the lead architect of your financial recovery. You have the tools to trace your separate property, calculate the tax-adjusted value of a Roth versus a traditional account, and navigate the complexities of 457 and 403b plans. The final word in 2026 is vigilance. The laws regarding retirement and divorce are not static. They are evolving with every new tax act and court ruling. Your financial security is not determined by the judge's signature alone, but by your persistence in ensuring that every dollar assigned to you by the court actually makes it into an account under your control. The gavel has fallen, the masterclass is complete, but your journey toward a secure, independent retirement is just beginning. By applying these forensic strategies, you are not just surviving a divorce, you are securing the structural integrity of the rest of your life. While the 401k is settled, the landscape of American wealth continues to shift. As we look toward the next horizon, we must ask, what happens when the assets aren't just in 401ks, but in the rising world of private equity, digital assets, and complex family trusts? The rules of the game are changing once again.